In this episode, we dive into the hidden challenges of divorce and immigration. Can your marriage or immigration status impact your future in ways you never expected?
Welcome to Women Winning Divorce, the podcast helping successful women navigate divorce with dignity so you can protect yourself, your children, and your assets. I'm Heather Quick, founding attorney at Florida Women's Law Group, where women win at life.
This week, we had Maria Aguila on the show, and we had a great conversation about the intersection of immigration and family law. I hope this episode is valuable to anyone who might be listening. Stay tuned for the full episode. Welcome to this week's episode of Women Winning Divorce. I'm Heather Quick, owner and attorney at Florida Women's Law Group. Today, Maria Aguila is joining us, and Maria is an immigration attorney here in Jacksonville, Florida, and has represented clients from the Philippines, Poland, India, Colombia, and many more countries. Today, Maria and I will be discussing the intersection of immigration and family law, the difference in a few different immigration statuses, and how your immigration status may affect your divorce. Welcome, Maria.
Hello, Heather. It's such a pleasure being on this podcast today. Thank you for having me. It's a real honor, and there's a lot to discuss, isn't there?
There really is, and it's so timely. There's a lot about immigration going on in the news, that is for sure. I'm getting ahead of myself. Please share a little bit about yourself for our listeners and basically how you got to be where you are today in your practice.
Right. I live here in Jacksonville. I have my practice in Jacksonville, and I live in Clay County. I got into immigration law in this practice. I'm actually born in the United States, but my parents are from the Philippines. They entered legally in the 1970s on medical work visa. My father was a doctor cardiologist, PhD, and my mother was a medical technician, and they became naturalized U.S. citizens. The employer petitioned them for their green card, or we also call lawful permanent resident. Immigration law has always been near and dear to my heart, and then practicing family law as well as adoption, domestic and international, just got added into the mix because I love to reunite and keep families together, even though, yes, we do divorce them too. I feel like the immigration and the adoptions can help unify families.
So I'm always intrigued by areas of the law that I don't practice because, one, it's good to, I only have a little bit of dangerous knowledge, right? To say, I know who you need to talk to. But it's just fascinating to me, and it is such a different practice. But let's start with a little bit. What trends have you currently been seeing in your practice regarding immigration and some family law?
Well, I could say trends, sadly what we're seeing are, instead of what used to be trying to petition and keep families together, the mass deportation efforts by the new administration has actually been ripping families apart. And so that is the very sad consequence of the mass deportation removal efforts of our government now. And even though we still have the immigration process available to keep families together, those that are here now, so for instance, U.S. citizen children born in the United States, if their parents are undocumented, they're now possibly in removal proceedings and sent back to their home country. Some of them already had prior removal orders and so on. So the trends besides that are leaning towards, okay, what do we do about the children that are left here? And what does that mean for those children? Who's going to take care of them if they are minor children? So you have to start shifting strategy to how do we take care of these children? Because they're legally here if they're born in the United States. They're U.S. citizens.
That makes me think. So because obviously immigration's federal, but, we have state agencies that look after, I don't know what the right word is to describe, like Department of Children and Families, but when there is neglect, when there is a child at risk, the state agencies often step in to then figure out who can take care of them or having those safeguards. So you think that's is that what's going to have to happen, you think? Because the federal government isn't set up to assess that, I don't think.
They're not. They'll defer to the states to take care of the children who may not have a legal guardian or other adult who's tasked to take care of these children. Already, we have our Florida Department of Children and Families already overwhelmed and understaffed as it is with just the regular children that they're dealing with and allegations of any abuse, abandonment, or neglect. And now we've got parents who might be just taken and no one's giving it a single thought. Where are there any children at home left alone? So what happens with that? I think because it's only in March and we have yet to really start seeing the results to the families left behind, I think that will ultimately, those storylines will explode in the media. And sadly, these are our clients that we're having to deal with the immediate issue of the immigration case of the individual. But then now you've got to, and what about families? Where are they? What's going on? Do you have children? So having a network of attorneys that it goes beyond just the immigration case now. May need a family law attorney. You may need an estate planning attorney, someone to deal with guardianship, the powers of attorney, and so on. And then another angle to that is we see a lot of non-lawyers, paralegals, we call them form fillers, that are doing this kind of work, and they are not lawyers. And they're telling everyone, oh, just fill this power of attorney, it's enough. And it's not. It is clearly not enough just to have a power of attorney over a child in the state of Florida to have full care and custody.
And so are you seeing an increase in people maybe with a risk of immigration status issues setting up like powers of attorney or being educated in their knowing they need to, I'm guessing, set up guardianships for the minor children here in Florida?
Right. So we've had a few calls about that, but sadly, I think there's this kind of, first it was kind of the announcements and all the executive orders, and this is what we're going to be doing. Then they started having local law enforcement involved, helping the federal immigration officials, and I think their families haven't thought about that. It's kind of a second thought, and I think there was the not wanting to believe that this could happen to them. And by the time it happens to them, it may be too late. The parent could be taken to a facility. We have to track down where that parent is, and then whether or not they will have a court hearing or will be placed in removal proceedings, then where do we go from there? And so I think we haven't yet seen families really making those plans. We're trying to encourage them to think of their disaster plan for that.
I know you speak a lot, but I'm guessing right now there is a lot of education you're trying to do to help people at least put something in place if you're right, because there's probably quite a bit of our population that they may not be here legally, whether they entered illegally or it expired, but they stayed, and now they're children who are U.S. citizens born here. And it's like, if this happens, I'm sure you're trying to help them say, like, be prepared, at least put this in place.
Yes, and we're trying to get them to start thinking that way, that we can't save everyone from removal. There's some that are entitled to relief, or at least to have their day in court, or let their petitions be adjudicated by the immigration agency tasked to review it. We are trying to encourage all clients in those situations to have a disaster plan, and then to start thinking who would be the guardian of your children, who's a trusted adult, who's a U.S. citizen or a permanent resident, who can care for the child or children. But it's kind of a bitter pill to swallow when they're still getting over the shock of the possibility that their loved one may not be able to stay in the United States. And then you have to get them past that shock and that, anxiety and emotional turmoil and tragedy, or trauma, if you will, to that point. I had a consultation and I had entire family, including the children, just crying, just desperate. And it was U.S. citizen children trying to explain to them, if this happens, we'll try to deal with it as it comes, but just be prepared that there could be the possibility that your family member will not be able to remain here.
And like in that situation, and I'll just say, speak broadly, because we're not,
Okay.
we don't give legal advice
Right.
on the show, right? Because we don't know the client, we don't know who's listening. But in general, would you say, and it may not even be something you can say generally, but like if you are here illegally and you're scared, because like, I think I'm going to ask you, I have a perception of what happens when you're detained, but I think you're just detained and you wait, and it's got to be extremely scary and uncomfortable. But rather than risk that and then eventually being sent back, I don't know, the time frame on that. Do you think that for people who have the ability to return to their country that they should?
I think it's always good first for them to consult with an immigration attorney to make sure we don't leave any rock unturned, that we investigate, really look at the possibility of relief. And if there's no relief, then you start looking at that scenario. Okay, if you were to go back, who do you have back at home still? And then getting the family members left behind to start planning. So you're absolutely correct that for some people there is no relief. And so you start looking at this, the self-deport is what they call it.
Yeah. So let me ask you though, what does I mean, I'm sure you do know, but I don't know, for someone who gets picked up, what's kind of the process? Like, where do they go?
It really depends. Examples I can give, for instance, someone who already has a prior removal deportation order could be already, they'll basically are executing what already existed and the removal order, and they could potentially just execute that order and put them on a plane and send them back because they were supposed to be already back in their home country. Sometimes they sign a voluntary departure, but they stay. And so there are supposed individuals who get picked up who are undocumented. I can tell you, let's say they get picked up because it was a traffic infraction and they discovered, local law enforcement can ask for their immigration status, discover doesn't have any proof of being legally here. They get taken to the local county jail, they get booked, and then local law enforcement contacts Immigration, Customs, and Enforcement, or what we call ICE. They are like the enforcement arm of immigration laws. And after they book that person, ICE then takes them into custody and puts them in a facility. Before, you used to at least know where to find them. They would say exactly where you can find them on the online record locator. But now it's like they're in the county jail, next thing you know, they've disappeared. And they have a state court proceeding, or they have, sometimes they're in removal already in immigration court, and finding out can't appear because they got taken to some facility in another state. I literally just had this happen. And and he's supposed to personally appear in a immigration court in Miami, tracked down to Louisiana detention facility, and he was able to appear, albeit not at the time that was scheduled, appeared the morning, not at 1 p.m. And so things like this used to be at least either catch and release the individual, or where they're going and where they're going to be put. Now it's a chase. It's chasing down, a client, and then telling the family, where is my husband? Where is my son? I don't know. I'm trying to find out.
Yeah, I would think that'd be really scary. The threat of that, knowing that could happen, I'm sure it has people very frightened. And hopefully, for our listeners, if you know somebody like that, if that's you, please reach out to an attorney. This is so difficult and complicated. Don't try to navigate this by yourself. You really do need that advice, because the landscape has changed. Just like you said, it used to be you know where they go, and now you don't. And if you're at risk for that, at the very least, the attorney can help prepare you for what may happen. Now, you mentioned earlier a naturalized citizen or permanent resident. What's a permanent resident?
Okay.
What does that mean?
The difference is a lawful permanent resident is someone who was not born in the United States, who was foreign born, who went through a very lengthy process to become a lawful permanent resident, or what we call green card holder. And that card is not actually green. That individual is legally here in the United States once they become a lawful permanent resident. They've been carefully vetted, but they do have restrictions, and they are subject to, they could be placed in removal proceedings due to crimes of moral turpitude. They could, or violent crimes could put them in removal proceedings. There are restrictions. Lawful permanent residents cannot vote yet. They have to become a United States citizen in order to vote. So if someone marries a U.S. citizen, that person who married the U.S. citizen is foreign born. They're not automatically a U.S. citizen. I think that's a myth or a misunderstanding that needs to be said, and that's not true. A lot of U.S. citizens marry someone who's foreign born. They're kind of in shock when we explain the lengthy and expensive process and thought, well, I married him, they should just be a U.S. citizen, right? No, they're not. They have to go through a process, and some can adjust status if they're here and some cannot, or go through a waiver process. Versus a U.S. citizen, either you're a U.S. citizen by birth or you are a naturalized U.S. citizen, meaning you were a lawful permanent resident for a period of time and you're eligible to apply for naturalization, or that's the name of the process to become a United States citizen, and that's its own process as well. But you have to become a permanent resident first, which is very hard to get, and then become a U.S. citizen if you qualify.
All right, there's a lot there. So that helps us, the intersection of immigration and family law. I think that what a lot of people would think about is exactly that. I met the love of my life in Bali or South America. We're getting married and we're coming back. How does that work? Let's just say that one for instance, because that sounds like a lot of movies I've seen. And you fall in love in this beautiful country, right? And then you want to come back together. Is it that easy? Because I'm guessing it's not.
It's not that simple. And it also depends, is your spouse still overseas in their home country or another country, or are they physically here in the United States, and what is their status if they're here in the United States?
Right.
Are they in overstay? Are they still in current status? So if someone marries someone foreign born, that U.S. citizen has to go through this process of petitioning their loved one who would be a spouse of a U.S. citizen. And there's a whole lot of paperwork, and the forms do change. One just came out January of 2025, what we call the adjustment of status, the I-485, and they didn't tell anybody. The government just said, oh, you got to use this new one. Usually they give you notice and give you a grace period to start using it. Nothing like that happened. So if they have to go through that process through USCIS, which stands for United States Citizenship and Immigration Services, and if that particular petition for their spouse gets approved, let's say if the person's still overseas, then they have to go through the consular processing and apply at the U.S. consulate. So there's step 2 after step 1 with our government. Step 2 for consular processing, and there's a whole filing and a very particular online system that they require you. So we've had to actually buy special equipment to comply with all of these procedures.
Now, okay, because I would think, all right, if they have a passport, because for the U.S., like, right, if we want to travel abroad, we travel, we don't have to fill anything out, but I've only traveled and come back, and that was the intent all the time. So let's say you have your passport and you arrive here, and I'm going to make it with your new spouse, right? But you're foreign born, but you're like, they didn't listen to this podcast, and they're like, no, we're just going to go home and I'm going to live with you. And so then they arrive here, because I would guess it's pretty, if they have a passport, is it pretty easy to get into the country?
No, not really. And that is a perk that I think as United States citizens, we benefit from being able to travel pretty widely throughout the world. Some countries do require certain visa or application or paperwork, but nothing as laborious or tedious as entering the United States. Certain countries members of the EU, Canadians. You can enter just being a Canadian or EU member. There's a visa, basically what we call ESTA, or availability of just coming for a visit. Those visit family, go to a wedding, go to a work conference maybe. That's okay from certain countries. But then there are a lot of countries that are not on that list of being able to do that, and they have to apply for a tourist visa. Students, let's say international students, a lot of the international students attending college or universities or graduate programs in the United States have to go through a process to get a student visa. Typically, it's an F1 student visa. And it's a lot of paperwork, and you have to go to an interview, go through the U.S. consulate in your home country, and it's getting harder. It's not a shock or surprise for individuals to be denied a tourist visa, and they've tried 3, 4, 5 times, and they get denied, and you have to prove family ties, and
and that would be just like for a tourist visa, it would just be for a short-term vacation, and they still aren't allowed.
Some want to come here and just go on a vacation. They may not get approved to come here. So we always tell our clients, don't book airfare and all that non-refundable stuff if you don't get approved.
Because what happened is when you arrive in the U.S. and go through customs, they're going to be like, where's your other paperwork? Like, you're not coming in. Is that what's going to happen? And you're stuck in the airport?
And a lot of scrutiny now because, and there's, in terms of, let's say you went through that consular process to getting a student visa or a particular tourist visa, they still have the discretion to turn you away at the port of entry if they don't think your answers comply or match with what you applied for. Maybe there's something in your record that they didn't see before and now it's alerted them, or they just didn't like you, your answers, and didn't believe that you're here to go to a vacation. They think you're coming in to work illegally.
I mean, discretion with the people at the port, and what kind of training, education do they have? Like, they just can make that decision, I suppose.
Now, they're supposed to go through training. All the federal agents, officers of agencies are trained. However, if anyone thinks that it's always consistent and the same decision for, the same for everybody, it's not, I can say from personal experience, my own relatives from the Philippines applying for tourist visas took 3 or 4 times before they got approved. And they had no intention of violating immigration laws, but they just didn't believe that they would come back from the United States. And they did. I mean, they finally got it. They came to visit and they went back when they were supposed to.
That's really interesting. I didn't have any idea. Like you said, we have a lot of privileges as U.S. citizens, and a lot of people want to come here. So this is something that has happened in our practice, and we need help with because, someone may call, they say, I want to get a divorce and have a green card. And, of course, that's how they tell us. Maybe inquire more because we don't really know, like, what is that green card mean, right? Because I think there's a lot of people might say that, but it could be a lot of options, right? As far as how, they're saying, hey, I'm here legally, but I want a divorce. And let's just talk a little bit about that, like in broad strokes, and because I think that's real important for our listeners to understand.
Yes, and that does come up quite often. So if someone is a green card holder and wants to get a divorce, maybe family law attorneys refer to an immigration attorney, because if the green card holder gets a divorce and they had what we call a 2-year conditional permanent residency, in other words, they got their green card through the marriage of the spouse that they want a divorce, then that's an issue because they want to get the divorce. But normally, then when before your 2 years as a green card holder, it's called a conditional permanent residency, expires, and you get the 2-year green card because you've been married to that U.S. citizen less than 2 years. Okay. And they want the divorce, but then it has that legal consequence. Well, then that means that your spouse will not be petitioning you to remove those conditions. It's called an I-751. You have to remove those conditions on your green card. Normally, if you remain married to a U.S. citizen spouse, the spouse is still petitioning you under that form.
Plug it in because they'll edit it out.
Okay, all right. Thank you. Okay. So sorry. I was like, I don't know what happened. Okay. I know. I had it plugged for a different Zoom hearing. Okay, give me 1 second. Okay, this is... Just want to make sure it's plugged direct to the power. I think we're okay. I will let you know. So I think it's charging now. Okay, we're good. We're set up. Okay. Okay, keep going. So we were talking about
the green card holder divorcing, and they're still within that conditional 2 years.
So what happens is, since they're getting a divorce, then likely the U.S. citizen spouse no longer is going to cooperate and file this form. Plus, you can't represent to our USCIS, the Federal Immigration Agency, that you're still together. And, you know, especially if you're separated, they have to know they're in the midst of a divorce. Maybe they're already separated, meaning not physically living together anymore. You can't make a misrepresentation or can't lie to USCIS about that. And so that means that the individual who's a conditional green card holder will have to self-petition. There's additional evidence you have to prove that at the time that individual married the U.S. citizen spouse, it was in marriage in good faith bona fide marriage, but it just ended up in a divorce. So that's one waiver. Some are abused, and then you have to prove that there was some domestic violence as a result. Maybe that's why that conditional green card holder wants to divorce the U.S. citizen spouse. That happens too. Right. And they were living together, and then that person became abusive. That could be grounds to file that petition to remove conditions by yourself, the green card holder, with proof of that abuse.
Which so that can be difficult, because we've practiced in domestic violence injunction court and all that, and right,
you're not really going, because you didn't remove the conditions. That means you're not a green card holder anymore. If you were unsuccessful, if it was denied, or you never file it, that would be very problematic. And the only difference then with the 2-year green card, if you're a 10-year green card, let's say the spouse who wants the divorce, who's a green card holder, already has what we call the 10-year card, but they got it through work, they got it through their own means, or maybe their prior husband or prior wife, and it's independent of their relationship and marriage to that U.S. citizen that they're trying to divorce, they're fine. Their divorce will not affect, to compare the 2-year green card holder who's married to the U.S. citizen, and that's how they got the green card, versus the person who already has a 10-year green card, even with the 10-year green card to the same spouse who they're trying to divorce, and they got the green card that way, they can still file for the dissolution of marriage in state court, and it shouldn't affect their actual 10-year green card.
So it just matters, why you got granted, what you petitioned for, right? Was it because of the marriage? Was it because of work? Whatever the reason, if the marriage changes that reason that you got your green card, then that could affect and put your ability to stay here at risk.
Exactly. And a lot of people who get green cards are predominantly, it's really 2 main ways. There are other ways that are a little more obscure, or are too complicated to explain in a short discussion. The main 2 ways are employment or family. And so a lot of what we do as family law attorneys, if someone is married and wants a divorce, and you find out one of the spouses is a green card holder, it's your own client, then it's important. How did you get it? And how long is that card for? And let me send you to an immigration attorney to make sure there aren't some serious consequences to your dissolution case.
Okay, so this is a question. You get a green card for a particular reason, right? And we know that the federal government is there's a lot going on, and there's, a lot of people undocumented. And let's say it was a 2-year period, and I imagine at the end of that 2 years, you're supposed to do something to make sure you can still stay. But what if you don't and people just stay? And they're really not here legally anymore.
Yeah, then you could be placed in removal proceedings. It's a very serious consequence.
Yeah.
And there's also a very serious consequence for people who are marrying just to get a green card, or the other way around, where the U.S. citizen may have a good heart. Well, I'm just trying to help someone, so I'm going to marry that person so they can stay here. And that is not a legitimate green card case. You know, as nice as that might be, the U.S. citizen trying to help someone, that's no reason to get married to someone. It should be for the right reasons to marry, let alone the immigration status. But
well, and you really don't want to mess with the federal government on this issue and be in, putting yourself in a situation where you're not being truthful. And if through their investigation they determine that, I just don't think that would end well for you. I mean, I don't know what they do to the U.S. citizen, but I mean, it seems like they'd fine you for the having to do all this investigation that's not into a real marriage, maybe. I don't know.
No, you're right. That's why I always tell clients, this, or anyone in presentations, don't lie. They'll figure it out so fast, and it's not something you should ever attempt. There are criminal consequences of lying, false misrepresentations, and flat lying, putting false information on immigration forms to get an immigration benefit has very serious consequences. And sometimes, if it's not intentional and it was a mistake because you checked the wrong box, then correct it right away. But at least have yeah.
Now, let's say your green card has expired and you're still here. Now that it's expired, it's probably harder to try to renew it if you even can, rather than at least attempting to do it when it was required. Is that a fair statement?
Yes. I think if you do things by the book and do file properly before the expiration with all the evidence and the filing fees and the correct form, the correct edition of the form, and it gets approved, you should be okay. If you try to late file it, you better have some explaining to do. Why is it late filed? Maybe someone got in a car accident. Maybe someone was caring for a sick relative. Maybe they didn't understand. They thought it was still good, and then they looked at the date and they realized, and they didn't understand the consequence of not filing. And now they're trying to do it the right way. I think if you provide explanation to our government of why, but at the same time, it's always discretionary.
Yeah. Well, and there's just a lot in the news right now going on about immigration. And of course, I don't know what's true or not, but I did hear a statement that they were saying, and this may be paraphrasing the president, I don't know, but that if you are a guest of this country, meaning you are here legally, but you're a guest, you better behave, because they are not going to afford you necessarily, I think, all of the protection that certainly not that U.S. citizen. And if they find that you've done something like protesting or whatever to be, not what they want as a guest of the country, they're feeling they're going to send you away potentially.
Yes, and I think we're probably discussing about the international students who participated in protests at certain universities. While we do have a First Amendment right of free speech, you can protest and disagree with what's going on, but then where our government starts to consider certain activities to be actually supporting terrorist organizations becomes the question. And voicing your opposition to genocide or killing, or however the protesters phrase it, is one thing. If they have evidence that these actual students were supporting Hamas or terrorist organizations of other kind, then I would expect that the government, the burden is on them to show that evidence, and not just be suspicious or think maybe they are, but we don't know. Maybe they're erring on the side of caution. Why don't we just terminate their F1 student visa and then just send them back, revoke their visa, which they have the discretion to do? But is it, too extreme where they are supposed to have a right to free speech and protest to the disruption What grounds do they have there? And are they allowing other students to similarly protest in the same way? There has been a very chilling, I know there's a chilling effect now. A lot of international, and students in general are maybe afraid now to speak up. And that's not how it's supposed to be. But sadly, universities, colleges are advising students to focus on studying and basically keep your mouth shut, which, is not really a democracy in my opinion, but it's unfortunate that F1 students need to know that, it is discretionary though. And any
Well, and I think that's the thing. They have more risks than maybe they would have in the past. And it's good to be aware, right, of what's going on.
Sure.
Our government is powerful at all levels. You don't want to be on the wrong end of that and not have known that that was possible. I've always told individuals, even in family law, we're in front of a judge.
Yeah.
And I've said many times in the past to the clients, I want you to know, because you may not know, he can put you in jail. And when you are aware of that, you need to temper your behavior, the way you speak, because they do have that authority. I've never been to jail. I don't want to go, and I wouldn't want a client to either. But you have to appreciate that's a lot of power over you as you stand in front of somebody. So you just at least appreciate it. Be aware of the circumstances you're in.
Correct. And it's just a different world that they're in, and they have to exercise caution. But what is also sad though is on the flip side of that, when you take an extreme response to that, then you could rope in the wrong people. They were just walking through, or whatever the scenarios may be. Do you really have concrete evidence that that particular student did, maybe you have the wrong person, or maybe that person was just trying to get from point A to point B and was in the middle of it. It makes it difficult to say, and you have to prove a negative. The student is put in the position of, I didn't, but we have a photo of you there. These issues aren't simple, and they're not easy, but I just want people to understand, exercise caution. But there is a huge difference between the U.S. citizen and then a permanent resident, and then someone on a non-immigrant visa, like a tourist or a student. So getting drunk in public and driving, like DUI, they're cracking down on that too.
Exactly. Or, your spring break. Be careful, right? You just got to be, you should always be that way, but there's just a whole nother level, and can have dire consequences and put you on a path of something you would not have ever expected. But I think that's, at least to the extent we're now, there's just a lot of, they just need to be careful and talk to a lawyer, understand your status and your risks.
Exactly. And a charge or conviction or something that you got in trouble for years ago may now come to bite you bad. And so we've already seen that happen with a permanent resident trying to re-enter the United States who had a very old embezzlement conviction, and she's detained. And so you have those individuals, they were fine before, had been back and forth from the United States on their green card, but now it's become a problem. So the discretion and the rules can change a bit.
Yes, and they have been, and they are. So definitely reach out to an immigration attorney. And now we are both in Florida, but immigration is federal law. So, for our listeners, understand, if you have questions, you can, reach out, of course, to Maria. But we've reached the end of our show. But before we go, Maria, could you impart on our listeners what you've learned about women and their resilience throughout your career and experience?
Oh, wow. I think women empower me. I see their resilience, and they're tough. They work hard. They love their families, their children. They take care of business. And then often they take care of business and do it with such grace and strength that it gives me strength, and it reminds me of how women, we can empower and lift each other up, and I think that's really important. And I think what your firm and your podcast do, and empowering and lifting women up and encouraging, to take care of themselves and their loved ones, and not to neglect themselves, and to help each other. I think that's a message, sadly, that isn't always shared, actually. We just kind of do our thing and take care of other people.
Yes, it has been a pleasure to have you on our show today, Maria. And also, where can our listeners find you for more information and resources?
Yes, so my law firm, you can find my information on immigrationlawfla.com. There are additional resources. I'm about to start putting the blog and supposed to start a YouTube channel. I got the equipment, but it's more of just snippets of information and links for both family and immigration in particular. And there are great resources out there from ilrc.org, Immigration Legal Resource Center, as well as the Americans for Immigrant Justice. And that particular website is aijustice.org. So for the community resources, I think those are really good, and they're in different languages as well.
Oh, wonderful. Well, we've reached the end of our show today. Thank you so much, Maria Aguila, for joining us to discuss the intersection of immigration and family law, the difference in a few different immigration statuses, and how your immigration status may affect your divorce. Thank you so much.
Thank you, Heather.
Listeners, if you or someone you know in the Northeast Florida area is going through or even thinking about divorce, you're not alone. Taking that first step can feel overwhelming, but it doesn't have to be. Our newsletter is filled with actionable advice tailored to guide you through this process. By signing up, you'll gain the tools to face the unknown with courage and see if we're the right fit to support you during this life-changing time. Don't wait. Click the link in the show notes, fill out the form, and take the first step toward building a brighter future today.